I don't know if you have before you or not, but I appeared on April the 6th, 2010, and I had her pass out this form to you. Here, in front of you. On April the 6th of 2010, I came to the Senate Judiciary Committee, and I had done this summary and this outline of some of my specific issues with the judiciary. And one of them is that they're reporting, and it's number 1, Part D. I think it's very important to note on their reporting, they've got 62% of the complaints are judges that don't follow the law. Now, judges take an oath to follow the law. And,
And you know, as a counselor, and I don't, that when it says they didn't follow the law as a layperson interpretation, I mean, that's dealing with the legal aspects of what a judge does. I mean, I can understand why so many are summarily dismissed, because I think a lot of complaints are people who are not happy with the result. And so that makes sense to me, that so many cases will be summarily dismissed because there's no malfeasance. There's no impropriety that the judge has performed. But the fact that they're dismissed, so many dismissed because on summarily dismissal, that makes sense to me, that so many people are going to file complaints. They're not going to be learned like yourself and maybe point out some actual conflicts and actual concerns. They're just going to be people who don't like the result. I mean, again, I said it earlier today, I've never seen anybody happy he goes to domestic relations court. When they go in, they're unhappy, and when they leave, they're unhappy, because it's just it's a problem in society, and it's a very difficult thing to do. So that doesn't surprise me or shock me or anything that so many complaints were dismissed.
But here's the problem. The problem filters through, okay? And actually, and Miss Johnson, Janice Johnson, brought you this form. I put this form together because part of the problem is the litigants don't understand how to do. Litigants themselves don't understand what is it. It doesn't feel right in there. It's not just people who aren't happy with he got 40% of the assets and I got 60%. It's people that are going, this doesn't feel right. As you've heard them say, my experts weren't allowed, my documents weren't allowed, I wasn't allowed a continuance. It's an unfair treatment. And litigants just go, that just doesn't feel right, but I don't know what to do about it. And attorneys can't do it.
And I'm sure Senator Jackson and yourself and I, all in the practice of law, I've had judges say very clearly, it's redundant testimony. I've heard enough. Now, if you're looking for blood, a lot of litigants are in court are looking for blood, and they can never bring enough witnesses to condemn the other person. And so I don't find a lot of sympathy for someone who the court system has a job to do, and you know this. I'm not lecturing to you. I think I'm speaking for the record that sometimes I'm still not sure that people who file a complaint saying I didn't get put on all my witnesses, that in and of itself to me is not something that merits review by this committee, because if you say to them, I think that you have to go beyond that, because I've always had judges who said, I've heard enough, counselors. How much longer? How many more witnesses? What's the substance of testimony and things of that nature? And I just don't know that I didn't get to hear all my witnesses is a complaint that this court can actually look at.
Okay, well, I want to draw your attention to what judicial misconduct is under 175302, which is on the second page. This is on that judicial complaint form. Judicial misconduct is willful misconduct, persistent failure to perform duties of office, violation of the Code of Judicial Conduct, violation of the rules of professional responsibility, persistent pattern of intemperate, irresponsible, or injudicious conduct, persistent pattern of discourtesy to litigants, witnesses, jurors, court personnel, or lawyers, persistent patterns of delay in disposing of pending litigation, and any other conduct calculated to bring the judiciary into public disrepute. I'm not talking about somebody who just doesn't get a call, their last 4 or 5 witnesses. I'm talking about that you can't get past that because the attorneys cannot assist the litigants in filing appropriate complaints if they need to be filed.
Because of the chilling impact of the filing?
Thank you.
That seems to be redundant also, that there's a chilling factor that I think Senator Jackson and Senator Morrell both have hit on, that there's a a chilling factor for lawyers and parties who have to go back before a judge to file a complaint.
Right, and it's public, and they know it, and they will, and respectfully, Judge Ash said, well, by the time we have the reprimand, the case is over. You're right. How much damage has been done in the meantime? And that's where the system begins to cave in. But because the attorneys cannot do what they need to do and get relief for the litigants in the courtroom, they can't. And you've heard this said before, and you've said it. Attorneys have more than one client. I have other clients who have been prejudiced and biased against because of the impact of me trying to stand up against the inappropriate conduct on other avenues. Now let me go on a little bit about, so I had the BPR complaints filed against me. So in 2009, I'm hit with this big petition, 8 counts of misconduct. One of them is by a judge in Davidson County who filed a BPR complaint 5 days after she received notice of an adverse Court of Appeals opinion that I had taken to the Court of Appeals, which scolded her for the 3rd time on her inappropriate and intemperate conduct in the courtroom. 5 days after she received that adverse opinion, she filed a complaint against me.
Was that in the record? The Court of Appeals put that in the record as the 3rd time?
They didn't say it was the 3rd time, but they referenced at least once, and my brief referenced the other cases. But they said again, well, it's not quite as bad as this other case, but the court should be counseled not to be so intemperate in the courtroom. Her complaint against me was an 8-year-old divorce case that was non-contested, that wasn't even before her, and the litigants never even complained. And she filed that with the BPR, and they prosecuted and filed a petition on it. I spent the whole year of 2009 defending myself before the Board of Professional Responsibility, and I tried to call the judges as witnesses. And the Attorney General gets involved in, oh, no, you can't call judges as witnesses. You can't question a judge about his deliberation process. I said, I don't want to ask them about their deliberation process. I want to ask them about what they're talking about me behind closed doors. Because one of the judges filed a complaint, and he goes, all the judges in Williamson County are joining me on this complaint. If they had not talked about something about me behind closed door and tried to spread the venom, then that would not have been the case. In February of 2009, I had a 2-day hearing in front of a hearing panel, which was 3 attorneys. They heard 2 days of testimony. I had an attorney and 5 litigants come in and discuss with the hearing panel the experiences that they had felt in those particular courtrooms, and how they had been silenced and prejudiced, and how the court process had interfered with my ability to represent them. The hearing panel dismissed the charges that were brought by the judges. The BPR appealed it. They appealed it. It was dismissed. They appealed it. How many times does the BPR appeal a dismissal? So it has been all about silencing. And I recently, so in April of this year, I used this form, assisted another complainant to file a complaint against some more judges in the Davidson County juvenile court system because of the things that they had done. No response, no response, no response, no response.
This is a complaint with the Court of Judiciary, correct?
Yes, this is of April of this year.
Did you get an acknowledgement from the Court of Judiciary?
No, I did not. I get a phone call about a week ago saying, and I sent a follow-up because I said, I haven't heard from you, and these additional things are happening to this litigant. And I get a phone call finally that says, we didn't get it. We didn't get it. Now, it was sent to the address on the complaint, which my others were sent there, so I don't know why they would not have gotten it. And here's, so we have in here, and I've got outlined in here, so we have recusal. Is recusal really a remedy in the courtroom? No, it is not. An attorney's not going to file a motion for a judge to recuse himself when it's heard in front of the same judge, and you have to go back in front of that same judge. And if you do file a motion for recusal, you have to do it kind of sheepishly, saying, well, Judge, I just want you to know my client thinks. You can't stand up. You cannot fearlessly represent your client. Attorneys are to be advocates and advisors to their clients in the courtroom in the pursuit of justice.
Well, in that line, you seem to be following the testimony of Mr. Hooker. So let's go back and let's conclude, because with the Court of Judiciary, you got no response. Have you refiled those complaints?
Well, as I said, I finally got a call last week.
Okay, but
after my April
from the
complaint.
Same complaint, or did you refile new ones?
I did not I filed a supplement because of additional things that had occurred since then.
So did you get an acknowledgement when that was received?
That's when I got the acknowledgement.
Okay, and the acknowledgement was a telephone call?
Yes.
Okay. Have you received written correspondence or acknowledgement saying they've gotten it or anything?
No.
Okay, very good.
Now, and just again to go back and summarizing this, one of them is they have the Court of the Judiciary does not have a duty to report unethical conduct to the BPR or criminal conduct. And I heard you make a comment earlier about the that's not their jurisdiction to prosecute criminal conduct, but they certainly are the purveyors of understanding. And you know, I pulled out in 18 U.S.C. 242. You know, it is a violation of a federal statute to deprive any rights or privileges protected under the Constitution. So they don't have a duty to report unethical conduct to the BPR. The judges are still attorneys. They need to have that duty to report so that they can then have to be under Rule 8 as well as under Rule 10. The confidentiality, and I've already talked about the silencing effect. The ease of the complaint filing is an issue. The open records, these are elected officials. I've heard you make more than one comment this morning about if you want to judge off the bench, you can go to the ballot box. Because these are not open records, they are elected officials, they should be totally open. People can sort through and determine what's real and what's not real. And there was a comment about Judge Ash made a comment about when they first come, they're only allegations. Now, I assisted Ms. Johnson in 2009 in bringing some things to the legislature. One was the Bill of Rights. Now, you said notice and or the litigants' Bill of Rights, notice and due process, but it involved a little bit more detail in that for a litigant to know that they should be respected in the courtroom, that attorneys will be given the opportunity to make objections in your behalf, that if you have a complaint and if your constitutional rights are being violated, here's your redress.
But isn't that the role of the lawyer?
Oh, yes, definitely.
Okay. But does the lawyer need that on the courtroom wall?
No, the litigants do, because
the litigants need the lawyers to be there.
But if the lawyers are silenced, and if they can't walk out of the courtroom and tell their client, you know what, the judge didn't do the right thing in there, and let's go file a complaint. If an attorney can't do that, then the litigants don't know where to go.
Members, do you have any questions before we conclude this? Our time is running short. Our soccer games are running over.
I just want one final thing about one of the things that we had asked for was either videos in the courtroom or the opportunity to video your own events in the courtroom. Judge Ash said that these are only allegations at this point. You know, when I was a prosecutor was when we put video cameras in the police cars for all the DUI arrests, and all the defense attorneys loved it because then the truth was there. It wasn't just the police officer standing up and saying, well, you had bloodshot, watery eyes. If you have the opportunity to video and what's transpiring in the courtroom, you can see what goes on. I will say that any complaint that I have filed pleadings, I have filed transcripts, I have filed the record.
Senator Kyle made that point yesterday that the openness of government has now reached the point where I think the court system is going to have to consider that as an option. So thank you for your presentation today, for being here. Members, do you have any questions?